So the only thing, we do, I'm just going to jump right into the agenda, but we have minutes to review. So you should have received minutes from January 24th, 26th, 27th, and 31st, and February 1st, 7th, 9th, and 10th. I hope you've had a chance to review those. Representative Neighbor.
Thank you, Madam Chair. I would move approval of the minutes as stated, for the dates as stated.
Okay. It's been moved to pass it. Do I have a second? Second from Representative Ousley. Any discussion? All in favor say aye.
Aye.
Opposed, no? Okay. Thank you. Okay, now we will move into our discussion on House Bill 2004, and we're going to start off with Jesse doing an overview, reminder of the bill.
Thank you, Madam Chair. Good afternoon, committee. Jesse with the Reviser Statutes Office. I'm going to take you through House Bill 2004 this afternoon, section by section, to refresh your memory, and maybe some new questions will come up, but also address some of the questions that you had last year. So looking at House Bill 2004, what this does is it adds a new section to the Adult Care Home Licensure Act, and it creates requirements for involuntary transfers and discharges and creates a right and a process to appeal that transfer or discharge. And additionally, in the S drive that Fran had emailed you about, my brief from last year is on there if you want to follow along as well. So in the House bill, under subsection A, where administrators and operators of adult residential care facilities have to ensure that residents are not involuntarily transferred or discharged unless a transfer or discharge is necessary because the facility cannot meet the resident's needs, the health and safety of others are endangered, the resident has not paid charges after a reasonable notice, or the facility ceases to operate. Currently, in Kansas Administrative Regulation 2639-102, subsection A is their subsection D. So this new subsection in this section currently exists in regulation. And so I'm going to point out through each subsection if that also exists in regulation. So subsection B of the bill requires that the administrator or operator notify the resident or any of their known legal representative of an involuntary transfer or discharge and the reason for that transfer or discharge. Except when a facility is no longer in operation, the transfer or discharge, so when someone is involuntary transfer or discharge other than the facility is no longer operating, it must be for one of these reasons. It must be for that the transfer or discharge is necessary for the resident's welfare and the resident's needs cannot be met by the facility. If such transfer or discharge is appropriate because the resident's health has improved and that resident no longer needs services provided by that facility. The rationale that such transfer or discharge is necessary to ensure the health or safety of individuals in the facility. And as well, it is required that the resident physician document those rationales and those reasons in the record. And so therefore, that subsection can be found in also 2639-102 and at subsection B1. So that section also already exists in the current administrative regulation. So administrators and operators must provide a written notice of the transfer or discharge. That includes the reason, the effective date of the transfer or discharge, the contact information of the state long-term care ombudsman, who spoke last week, and the resident's right to appeal the involuntary transfer or discharge that is new and going to be later on created in this section. So if a resident has an intellectual or development disability, the notice shall include information of agencies responsible for the protection and advocacy of those individuals. And if the resident has a mental disorder, the notice shall include information of agencies similarly responsible for that resident as well. And this notice shall be provided to the resident or the resident's legal representative at least 30 days prior to the transfer or discharge, unless the safety of others would be endangered or the resident's needs require an immediate transfer to another healthcare facility. So when we talk about this 30-day notice, that 30-day notice is going to be subsection F of the Kansas regulation. So the regulation states that the administrator or operator shall provide a notice of the transfer or discharge at least 30 days before the resident is transferred or discharged, unless under the same circumstances that the safety of other individuals in the adult care home are endangered or there are urgent medical needs. So that they are the same two reasons in which notice is not required. In subsection D of the bill, it requires that there's sufficient preparation and development of a discharge plan that shall be provided to the resident, and if practical, the resident's legal representative and designated family. And so these the language of subsections A through D are currently found in the Kansas Department of Aging and Disability Services rules and regulations, as I was attempting to compare the two as we went along. So in House Bill 2004, the new part is going to be subsection E. And if you have the bill in front of you, that is going to be on page 2, and that's lines 31 through 42. And so what this does is it establishes the resident's right to appeal an involuntary transfer or discharge that's in violation of any of these requirements that are set forth in the section, and they appeal that to the secretary for KDAD secretary. And so a notice of appeal must be filed with the Office of Administrative Hearings within 15 days of receiving a notice of transfer or discharge, and then a hearing shall be held within 30 days of the notice of the appeal. And when the appeal is pending, the resident is permitted to return and resume residency in the facility. So that part about being permitted and returned is in part 2 of that subsection E. So the language of subsection E is not found in the regulation that contains the other language, but what it does is that this section, as well as the rest of the section and regulations promulgated by KDADS, is that it closely follows the language of federal law that governs this same process for nursing facilities. And so this differentiation is important because at the end of the bill, kind of as used in this section, subsection G, has adult residential care facility, and that defines it as an assisted living facility, a residential healthcare facility, home plus or boarding care home, as they're defined in the Adult Care Home Licensure Act. So that definition does not include nursing facilities, since there's a federal law that already allows this process and this appeal right and these requirements for nursing facilities. And I think that is all I have in reviewing that bill. So I'm open for any questions the committee has on what we just went over.
Thank you, Jesse. Appreciate your thoroughly covering that. It's been a while. Representative Mosier.
Thank you, Madam Chairman. Jesse, so I've got your same brief here, and A and B are in statute, is what you said. I just want to. Sure. Okay, and then at the top of the second page, the first couple of sentences, you said that will be new to the bill.
So on page 2 at the top, when you're talking about providing a written notice of the transfer or discharge, right, that includes the reason, that is going to be already part of a regulation. Let me double check. So part of that is not in regulation in regards to the information that's required to be in that notice, such as, services for that or services for these certain persons. But the part that already exists in regulation is that the notice shall be provided to the resident or the legal representative within 30 days prior to the transfer or discharge. And that is subsection F of the current regulation. And then that is also has the no notice is required when there's an endangerment or.
In those two
needs.
instances that you have spelled out. Okay.
Correct.
Thank you. Thank you, Madam Chair.
Representative Helmer.
Thank you, Madam Chair. I just want to clarify it. And I see different terminology being used: adult residential care facility, assisted living facility, residential health care facility, home plus or boarding care home. But in the end, this person still has sundowners, So when it's all said and done and we've gone through this, where is this person going to be cared for when it goes through the legalities?
Madam Chair. So all these different phrases have different definitions in regards to what level of care they provide and those sort of things. So I guess to generally summarize, they are in some sort of facility that is providing some level of care for the resident.
So may I ask this? So does that paragraph there imply that gives that's the process of going through where that person is placed?
Madam Chair, thank you. Representative Helmer, which paragraph are you speaking about specifically?
On page 3, beginning on 2 through 5. Line 2 through 5, 2, 3, 4, 5.
Oh, yes. So Representative Helmer, so that is just stating how this involuntary transfer discharge process and appeals right, which facilities it applies to. So at this point in time in a person's process of being in a facility, this only relates to that point in which they're being involuntarily transferred or discharged, and whether they live in which one has already been predetermined. So this is more on the end side, possibly.
And that's what I'm referring to. Thank you very much for your answer. Thank you, Madam Chair.
Further questions for Jesse regarding the bill? Representative Wagner.
Yeah, Jesse, no, thank you very much for the explanation. I'm kind of following most of what you're saying, but you said most of this is already in current regulations, and the regulation you referenced is KAR something, or what?
Yes, Madam Chair, thank you. Representative Wagner, the KAR that has a majority of these sections existing regulation is going to be 26-39-102. And that also, the way that regulation currently exists is the regulation has admissions and other requirements that you wouldn't find in this. So this is only implementing in statute the involuntary transfer and discharge part of the regulation.
If I may, another question. So when you have the appeal, they have the 15 days, they're supposed to get a 30-day notice. After 15 days of that, they can file a notice of appeal to the Office of Administrative Hearings. They're supposed to have that group is supposed to meet within 30 days after the receipt of the notice of appeal. And so if that group denies their appeal, how many days after that before something has to happen as far as change of location? Is there another 30 days on top of that after the appeal? Is that?
Yeah, Representative Wagner, the bill is silent as to whether or not the appeal has been decided this way or that way on where that person would go, whether they stay or not. As far as other day requirements through that process, that would be found in the Administrative Procedure Act, but that also would be silent as to whether the person would go after a ruling.
One other question. So in one of the testimonies from, I think one of the nurses, KHCA, which is, I guess, a nursing trade group, they reference KAR 26-41200 on resident criteria that already has certain conditions under which a person is not to be admitted or retained. And so does that then become inoperative as far as with something like this supersedes all of that, or would it not? I mean, it mentions, incontinence, immobility, an ongoing condition requiring 2 or more persons to physically assist the resident. I mean, my question would be, those are kind of specific things as which an assisted living center is not supposed to keep somebody. Is that would be all superseded by what the 2004 says then?
Yeah, Madam Chair, Representative Wagner, yes, I know, I understand what you're talking about. I'm not very familiar with 2641, as you mentioned, but this only applies in the instance in which someone is involuntarily discharged or transferred, and so it seems that this KR 2639-102 is only in that instance. And so if there's an instance of another sort, that's likely governed by 41. But in case there is a direct conflict when it comes to involuntarily discharge and transfer, the statute would rule over that. And so that would either cause the department to go through rules and regulations, or they could bring an issue to the legislature to be able to fix it as well.
Further questions? Okay. Thank you, Jesse. Okay. So Fran has sent out put on the S drive all the testimony from the previous hearing on this bill. So can I ask, what's the committee's wishes to do with this bill? Representative Neighbor.
Thank you, Madam Chair. I would move that the committee pass out favorably HB 2004.
Okay, it's been moved by Representative Neighbor and seconded by Representative Helmer to pass out favorably. Is there discussion? Do we have amendments? Representative Smith.
Thank you, Madam Chair. I really like the bill, but as a last resort, if they were asked to leave and there's no place to go, what would we do? Does that make sense?
Can you say that again? What you mean?
If they were discharged from a care home and
they haven't made arrangements?
And well, there's maybe no other place that wants them, or what do we do as a society, I guess? I mean,
That's what this provides for them to have the ability to appeal the discharge.
thank you, Madam Chair.
Further discussion? Representative Ousley.
Thank you, Madam Chair. And I'm happy we're here continuing this conversation. I'm willing to go with the committee's wishes upon this, but I would still prefer to see the Judicial Council report before we get too much further with 2004. But I understand with deadlines coming up, that this might be a necessary step to take to keep the conversation going this session and not to wait until next session. So I'm willing to go along with the will of the committee.
So if you recall last year when we had discussion about this bill, I'd stated at that time that I was going to write a letter to the Judicial Council, which I did. I just did that in December because the senior care task force was not getting far enough into the conversation to have an impact on this session. So, and they have received the letter and they have agreed to it. They decide what topics they will study, and they have agreed to study this topic. So that is out there, but at this point, we're just moving forward on the bill to see what kind of discussion, what the committee would like to do. Representative Neighbor.
Thank you, Madam Chair. We had an incident in Johnson County, or in the area, where a gentleman was in the hospital, and when he went back, they didn't want to take him in the nursing home. I think this gives an option or an opportunity for a person in that situation to say, I want to appeal, I want to have people understand, and I want to know what my rights are, and why are you dismissing me, because I basically have nowhere to go. I think this opens the door for conversation. I don't know how much we'll use it, but I think it's important that we protect our seniors against being put out on the sidewalk with nowhere to go and no notification. This may not be the be-all, but it certainly opens the door and gives us an opportunity to help those individuals, gives them their right for an appeal and for proper conversation to take place. I think that's extremely important for the individual and quality of life. Thank you, Madam Chair.
Representative Helmer.
Yes, ma'am. I've dealt with sundowners personally, and I just looked it up, and right now it's guessed that there may be up to a third of Americans that may be dealing with sundowners at one time or another. It's a very, very serious thing to deal with. I'm dealing with it right now with a friend's mother. It's all that they can deal with in a care home. We need to really think about this very seriously. I've buried 2 sundowners victims. It could strike any of us. It's not something that we can just be throwing people out of care homes. We need to care for our loved ones. Thank you, Madam Chair.
Further discussion. Representative Wagoner.
I mean, if there are amendments coming, I'm sure we'll have further discussion with that. But I did want to, and I remember the original hearing we had last year, and then got back all of the new testimony, and I was taken by the fact that that there are certain things that assisted living centers are different than nursing homes. I mean, they're different than other types. I have a multiple number of nursing home and assisted living centers, in my district, and of which a number of them have reached out to me on this with just a genuine concern that you have people in assisted living where, when their health is going down, where it is no longer an assisted living type of scenario that they need as far as nursing and as far as care, and that you're putting them in a really awkward situation by taking what you already have as a regulation that they mentioned in this KAR 2641-200 on resident criteria, and basically telling them that they really can't follow that, that you're going to give somebody, an automatic right to appeal that can delay things, up to 60 days or apparently longer. We're not totally sure. And just, folks who are in the care business realize that, there's appropriate care for somebody in a nursing home, there's appropriate care for somebody in assisted living, and that if you're forcing them to be providing nursing home care, to somebody who's in assisted living, it's a totally different cost structure, a totally different staffing level. And I think that there really are some very legitimate concerns of the industry that I don't think are addressed. And I do think I was kind of amazed by just the testimony, how many protections or safeguards there already are in when you have somebody in assisted living, you know, before a agency can tell them or a home can tell them that they just can't care for them anymore. And so with that, I mean, I would tend to think, I know the bill's very well intentioned. I know you can have horror stories in any sort of situation, whether it's regulated or unregulated, but I don't think 2004 is certainly as written is really what we need in this situation. Thank you.
Further discussion? Okay, seeing none. Representative Neighbor, you may close.
Thank you, Madam Chair. I think when we get into details of this magnitude, it's a good thing to have questions, the why, the how is this going to work? But I also know if we don't make movement on this, we could have people standing on the sidewalk with nowhere to go and no right to appeal. That's unforgivable. And I understand there is a difference between assisted living and nursing homes. And all of those entities know that there is a difference between what needs to be done. And oftentimes, assisted living is associated with a nursing home and they can move up to a higher level of care. So that option oftentimes is there for that individual. And that's a good thing that they've reached their level of assisted living and know that they need more and they can move up. But if we don't open the door and give opportunities, and we have more of an aging society today than we've ever had, then what are we going to do? And where are these people going to go? My mother had Alzheimer's. I thought it would be 2 or 3 years, and 10 years later, after us keeping her at home, it was not manageable. In fact, the doctor said, I think he kept her 2 years too long. I'm surprised. You have sanity. And we as families try to do the best we can with a home care situation, but we don't always have the ability to retain individuals in our home. They wander 24 hours a day. You have to lock doors. To me, it's like a caged animal. Nursing homes have people that are trained to do this, and they are compassionate. They're caring. They speak softly. They don't get angry because they understand their clientele. When do we make a difference in a person's life? Not when they're born, necessarily. Not in middle age. We've got to see them all the way through life, and we need to treat them with dignity, and we need to give them the opportunity to be the best they can be for as long as they're with us. I move my motion.
Okay, committee, all in favor of passage 2004 out favorably, please say aye. Aye. Opposed, no. The ayes have it. The bill is passed. Okay, committee, we have two bill hearings tomorrow. We've got a deadline of Monday for before turnaround. Monday is our last day of committee. And so we're going to have here House Bill 2700 and House Bill 2632 tomorrow. I don't, at this time, plan to work any bills tomorrow. But you might be prepared if there's anything that we've had a hearing on. If we're going to get it out, we've got to get it out before, Thursday. We're not meeting Friday. Monday, we'll meet on call of the chair. So at this point, I don't plan to meet on Monday. But we'll see if we have any wrap-up work to do. Okay, thanks. We're adjourned.